the Divorce Education Series presented by Findling Law. I'm Daniel Findling, and in this topic we're going to discuss child custody evaluation. So what are child custody evaluations? Well, the Michigan Child Custody Act requires that a court look at 12 child custody factors, and we have a webinar that talks about these specifically. But these are 12 factors that the court must evaluate in making a determination in a contested child custody case. And what child custody evaluations are is an opportunity for the court to punt, to say, wait a minute, before we have this long trial or hearing to try to determine what's in the best interest of the minor child or the minor children, as the case may be, let's refer it to a third party. Now, that's typically the friend of the court who uses a family counselor or sometimes a referee or an MSW to go through these 12 child custody factors. But it doesn't always have to be the friend of the court. So not only the friend of the court, but also community resources. Wayne County has a family counseling and mediation unit. You pay them a few $100s, you get an MSW that's probably right out of college that will do a child custody evaluation to assist the court in these 12 child custody factors. Now, if you can afford it, and if it's highly contested, nothing really beats the accuracy and the thoroughness of a clinical or forensic psychologist. These are typically PhDs, they're doctors that are specifically trained in handling child custody evaluations. So let's talk about the advantages and disadvantages of both a friend of the court or third-party community resource versus a forensic psychologist. Friend of the court is typically free. If you use something like the Family Counseling and Mediation Unit, there generally is a low cost. Sometimes it's $400 or $500. A forensic psychologist can be thousands of dollars. Average is between $1,500 and $10,000 over the course of 17 years that I've been practicing. That seems to be the range, depending on the amount of time. An advantage of using a forensic psychologist is you get to choose your evaluator. That's part of the negotiation process. Hey, let's use Dr. So-and-so. And you may know that Dr. So-and-so has an inherent bias, let's say, in favor of the father or in favor of the wife, or this judge doesn't like this doctor. Maybe we don't want to choose that doctor. When it's the friend of the court, it's who's ever available. You really don't have a choice. All right, now both the friend of the court and forensic psychologist will attempt to have the parties mediate. Let's see if we can get the parties to agree on parenting time and custody. Now, by the time you've gone to a child custody evaluation, the chance of that happening is really diminished. But don't lose hope. Quite often I've seen where there's been referrals to a friend of the court for child custody evaluation and the parties wind up settling or reaching an agreement. Now, psychological testing is typically reserved only for the forensic psychologist. You will not see a thorough psychological exam in a friend of the court or a third party. And then it goes with the expense. It just isn't the time or the resources, and quite often the qualifications for the friend of the court referee or a psychologist working for a family counseling or mediation unit to conduct psychological testing. Reports tend to be less comprehensive with the friend of the court. You might get a one-page summary or just a recommendation or a two-page summary. With the forensic psychologist, the report is typically 30, sometimes 40 pages long. There's no formal procedure with the friend of the court. Sometimes it's just, what he or she wants to do, what he or she thinks is important. Sometimes it's a gut feeling after a half-an-hour interview. With the forensic psychologist, there is a systematic, formal procedure with multiple interviews, multiple times at the multiple tests typically, and a much more comprehensive report as a result of that. So basically, this is, you get what you pay for in terms of the comprehensiveness of the report. Certainly not the. So let's talk about what a child custody report should read. Now, you'll see them all over the place. Sometimes at the front of the court, you just get a one-page summary or a two-page summary saying this is what I feel and why. But you'll see the reports are usually structured, the reason for the referral, the procedure that we use, the documents that we reviewed, what's the clinical observations, relevant family history, interviews with the children and sometimes the parent, observations on how the parties act, how they parent. Maybe there'll be a mock, playtime with the children and the parent. And then a summary. This is really where the lawyers start to look at. When you get the reports, you'll learn really quickly. You always go to the end because the recommendations are there in the summary. The summary are these 12 child custody factors. The law of affection, existing emotional ties between the parent and the child. Does it favor mom? Does it favor dad? And so forth and so on. And then the recommendations of what this child custody evaluator believes is in the best interest of the minor children or child, as the case may be, as it relates to parenting time and custody. That is the meat of these child custody evaluation reports, the summary, and then, of course, the recommendations. And if you're going to attack a child custody report, if you don't like the outcome, the first thing you want to do is look at the summary. What does it say? How does it apply the best interest factors? And then go through specifically the procedure and the testing itself, maybe with an independent expert to collaterally attack it. All right, so I've mentioned psychological testings and a forensic, of course, custody evaluation. What are they? Well, there's the MMPI-2. It's a personality test. It is a bunch of questions, 500 or 600 questions. Takes about 90 minutes, and it's administered to parents in a custody battle. And it literally has, you take a look at these reports, and it says the individual is trying to put themselves in the most positive light, and this is a bias, or the individual is this, they're narcissistic, whatever the case may be, but you're starting to get objective data. Now, it's important to understand there is not a psychological test that can accurately determine what's in the best interest of a minor child or children. It just doesn't exist. But these buttress an opinion. It's something more than this is just my gut feeling. The Rorschach test. Everyone's seen the Rorschach. They're usually mocked in cartoons like Bugs Bunny. They're ink blots, okay? They're presented to the individuals, and there's interpretations and impressions. If you see an ink blot, I think I'm going to hurt somebody, that's probably going to raise a concern. So do therapists give a lot of weight to Rorschach tests? The answer is yes, but from a lawyer and judge's perspective, it really is, does this complement your other findings? Is that not in a vacuum, what is the Rorschach test, but what does it say when looking at it with the MMPI-2 and the clinical observations and so forth? Does it support your theory or hypothesis as it relates to it? All right, the MCMI-3 really, this is, are you suffering from a psychiatric disorder? The DSM-5 is a diagnostic and statistical manual of mental disorders. The DSM-5 is the brand new version of it, and this clinical multi-axis inventory is a test to see if you have a specific disorder that may be relevant. Now, just because you have a specific disorder, whether it's depression, bipolar disorder, whatever the case may be, does not mean that you're not going to get custody. It's just relevant in making a determination as to whether or not the best interests of minor children are spent with you or with all right. Now, obviously, we've covered a lot of areas here. This is a very complex and complicated area of the law. I firmly believe that anyone going through a child custody evaluation should meet with the lawyer and talk about what to expect, what type of questions, how do you best prepare for it, and how do you present yourself in the most favorable manner to get the outcomes that you want. We know it's inevitable that you're going to have questions. We're here for you at Findling Law. Call us toll free at 877-YOUR-FIRM. That's 968-7347. Go ahead and email me. I provided my email address there on the screen. I look forward to working with you. You can, of course, visit me at thedivorceguy.com as well. I wish you a good day, and hopefully you found this both educational and meaningful.